Welcome to Chapter 11 of Criminal Procedure. This chapter is called Civil and Criminal Remedies for Constitutional Violations, and it addresses a fundamental question that flows directly from what we studied in Chapter 10. If the exclusionary rule is not enough to deter police misconduct, what other tools do we have? The exclusionary rule focuses on evidence at trial, but what about the person who is unlawfully arrested and whose charges are dropped? They never get to invoke the exclusionary rule. What about the victim of police brutality who is never charged with a crime? What about the defendant who plea bargains and never challenges the search? For all of these people, the exclusionary rule provides no remedy at all. This chapter covers three categories of additional remedies: civil suits for money damages, criminal prosecutions of police officers, and administrative disciplinary procedures. Each focuses directly on the officer's conduct and accountability rather than on excluding evidence at trial. We'll spend most of this lecture on the primary civil remedy, Section 1983, which is the federal statute that allows individuals to sue state and local officers for violating their constitutional rights. We will also cover immunity doctrines, the affirmative duty to protect, municipal liability, Bivens actions against federal officers, injunctions, pattern or practice suits, state tort remedies, criminal prosecutions, and administrative procedures. By the end of this lecture, you should understand the full landscape of tools available to hold law enforcement accountable for constitutional violations. Let me walk you through the 13 learning objectives for Chapter 11. This is a long chapter, so having this map in mind will help you navigate it. Objectives 11.1 through 11.3 establish the framework, what civil remedies exist, what Section 1983 is, and what constitutional rights it protects. Objectives 11.4 and 11.5 get into the critical questions of who can be held liable and when immunity shields them. These are among the most practically important sections because immunity doctrine significantly limits when officers can be sued. Objective 11.6 addresses the affirmative duty question. Can the police be sued for failing to protect someone? The short answer is generally no, with narrow exceptions. Objective 11.7 covers municipal liability. When can a city or county be held responsible for an officer's conduct? Objectives 11.8 and 11.9 cover two additional enforcement tools: injunctions, which order departments to stop unconstitutional practices, and pattern or practice investigations, which allow the federal government to reform entire police departments. Objectives 11.10 and 11.11 cover alternative civil remedies, state tort suits, and Bivens actions against federal officers. And objectives 11.12 and 11.13 cover the non-civil remedies, criminal prosecutions of officers, and administrative disciplinary procedures, including internal affairs and civilian review boards. Let's start with the big picture. The exclusionary rule, as we saw in Chapter 10, is limited in important ways. It doesn't punish the officer. It punishes the prosecutor. It doesn't help victims who are never charged. It doesn't help defendants who plea bargain. And the educational impact on the police may be minimal because the legality of a search may not be definitively resolved until years after it occurred. For all of these reasons, there are three additional categories of remedies available to address police misconduct. Civil remedies are the focus of most of this chapter. An individual who has been harmed by a constitutional violation may file a civil suit for money damages, compensatory damages for their actual harm, and in egregious cases, punitive damages to deter future misconduct. The primary vehicle for suing state and local officers is Section 1983 of the U.S. Code. For federal officers, the equivalent is a Bivens action. Officers may also be sued under state law for common law torts. Injunctions may be sought to stop ongoing unconstitutional practices, and the Department of Justice may bring pattern or practice suits against departments with systematic problems. Criminal remedies are less common, but significant. State prosecutors may charge officers under the same criminal codes that apply to everyone else. Federal prosecutors may charge under civil rights statutes that specifically criminalize constitutional violations committed under the color of law. Administrative remedies are internal to the police department or external civilian review processes. An officer may be investigated, disciplined, demoted, suspended, or terminated for violating departmental regulations. Here's a critical point students often miss. A police officer may face all three categories of remedies for the same conduct simultaneously. This is not double jeopardy. The prohibition on being prosecuted twice for the same offense applies only to criminal proceedings. The Rodney King case is the classic example. The officers were acquitted on state criminal charges. Two were then convicted in federal criminal proceedings for civil rights violations, and King won a $3.8 million civil judgment against the city of Los Angeles. Section 1983 is the most important civil remedy for constitutional violations by state and local law enforcement, and it has a fascinating and important history. The statute we know as Section 1983 was originally enacted as part of the Civil Rights Act of 1871, also called the Ku Klux Klan Act. Congress passed it in the aftermath of the Civil War to protect black citizens and Union sympathizers in the South who were being terrorized by Klan members, many of whom worked for or in cooperation with local governments. The law sat largely dormant for nearly 90 years. In 1961, the Supreme Court revived it in Monroe v. Pape. 13 Chicago police officers broke into James Monroe's home without a warrant, forced Monroe and his family to stand naked while they ransacked the premises, took Monroe to the police station, interrogated him for 10 hours without allowing him to contact his family or an attorney, and eventually released him without any charges. Monroe sued under Section 1983. The Supreme Court held that the act applied to police officers and other representatives of the government who abused their official authority. That decision opened the door to what has become a major area of civil rights litigation. A Section 1983 plaintiff must establish three elements by preponderance of the evidence. First, color of state law. The defendant must have acted under the authority of state law. This is satisfied even when the officer exceeded the limits of that authority. An unlawful arrest is still an act under the color of state law. The analysis gets more complicated with off-duty officers. Courts look at whether the officer used police-issued equipment, identified themselves as an officer, and whether departmental regulations required them to enforce the law at all times. An officer who shoots someone in a private bar fight without identifying themselves and using their personal weapon is less likely to be found acting under the color of law than an officer in uniform with department-issued equipment intervening in a disturbance. Second, violation of a constitutional or federal right. The plaintiff must identify a specific constitutional right that was violated. Common claims include unlawful arrest or search under the Fourth Amendment, excessive force under the Fourth Amendment, coerced confession under the Fifth Amendment, denial of counsel under the Sixth Amendment, cruel and unusual punishment under the Eighth Amendment, and in deadly force cases, a violation of the constitutional right to life. Importantly, the violation of a state constitutional right does not support a Section 1983 claim. It must be a federal constitutional or statutory right. Third, the absence of an immunity defense. Even if the first two elements are met, the defendant may be shielded from liability by either absolute or qualified immunity. We will look at those in detail on the next slide. The immunity doctrines are critical to understanding when Section 1983 suits actually succeed in holding officers accountable. There are two categories: absolute immunity and qualified immunity. Absolute immunity is granted to judges, prosecutors, witnesses, and jurors for acts undertaken as part of the judicial process. This means a Section 1983 suit will be immediately dismissed if filed against one of these individuals for their conduct during a trial or judicial proceeding. The immunity covers even corrupt or biased acts. A judge who unconstitutionally convicts civil rights activists cannot be sued. A prosecutor who knowingly uses false testimony at trial cannot be sued. The rationale is threefold. Without absolute immunity, every losing party would sue the judge. Judicial decision-making would be corrupted by the fear of personal liability, and errors can be corrected through the appeals process rather than through civil litigation. There are important limits. Absolute immunity only covers judicial functions. In Forrester v. White, the Supreme Court held that a judge who fired a probation officer was not immune because that was an administrative rather than a judicial act. In Burns v. Reed, the court held that a prosecutor had absolute immunity for their conduct at the probable cause hearing, but only qualified immunity for advising police officers on whether they could interrogate a suspect under hypnosis. Qualified immunity is the standard protection for police officers, prison officials, correction officers, and probation officers. Under qualified immunity, an officer is only liable for violating a clearly established right, meaning a right that any reasonable officer in that situation would have known about. The three-step analysis. First, did the officer violate a constitutional right? Second, was the right clearly established at the time? Third, would a reasonable officer have understood that their conduct was unlawful? If the law was unclear or contested, the officer is shielded from liability, even if they actually violated a constitutional right. This doctrine has generated enormous controversy. Critics argue that it effectively immunizes officers because courts require near identical prior cases to establish that a right was clearly established. And that standard is nearly impossible to meet in novel fact patterns. Defenders argue that officers must be able to act decisively in rapidly evolving situations without fear of being second-guessed years later in litigation. Casella v. Hughes is one of the most important recent Supreme Court decisions on qualified immunity, and the facts are genuinely contested. Officer Andrew Casella was responding to a radio report that a woman was hacking a tree with a knife and behaving erratically. He and two other officers arrived to find Sharon Chadwick standing next to a car in a driveway, separated from the officers by a chain-link fence. Then, Amy Hughes emerged from the house carrying a large kitchen knife. She walked toward Chadwick and stopped about 6 feet away. The officers drew their weapons and twice ordered Hughes to drop the knife. Hughes appeared calm, did not acknowledge the officer's presence, and did not drop the knife. In under a minute from the officer's arrival, Casella dropped to the ground and shot Hughes 4 times through the fence. She survived and was treated for non-life-threatening injuries. After the shooting, the officers discovered that Hughes and Chadwick were roommates, that Hughes had a history of mental illness, and that the dispute was about a $20 debt. Chadwick later stated in an affidavit that she had never felt endangered. The issue before the Supreme Court was not whether Casella's conduct violated the Fourth Amendment. The court explicitly denied to decide that question. The only issue was whether the violation, if any, occurred, was clearly established. The majority, in a per curiam opinion, without oral argument, held that Casella was entitled to qualified immunity. The court emphasized that existing Ninth Circuit precedent, particularly in Blandford v. Sacramento County, actually favored Casella because the Ninth Circuit had allowed the use of deadly force against a man wandering a neighborhood with a sword who refused commands to drop it. The cases the Ninth Circuit cited to deny immunity were either decided after the shooting, involved materially different facts, or, as the court put it, did not pass the straight-face test in terms of their resemblance to Casella's situation. Justice Sotomayor's dissent is powerful and worth reading carefully. She argued that the majority's account of the facts was cherry-picked. Hughes had committed no crime. She appeared calm and composed, not erratic. She had not raised or pointed the knife. Chadwick, who was standing right next to Hughes, said she was never threatened. The officers gave rushed commands in quick succession without identifying themselves as police, without warning they would shoot, without attempting less dangerous de-escalation measures, and without giving Hughes time to register their commands. Most significantly, Sotomayor argued every other officer at the scene declined to fire. Casella alone escalated to deadly force. Sotomayor concluded by accusing the majority of creating an absolute shield for law enforcement and telling officers they can shoot first and think later. The debate over qualified immunity continues. Several members of Congress have introduced legislation to eliminate or reform the doctrine. Some state legislatures have already done so. Two of the most important but frequently misunderstood aspects of Section 1983 are the affirmative duty to protect and municipal liability. I'll address both. On the affirmative duty to protect, the intuitive assumption is that the police are obligated to protect the public from crime. The legal reality is that they generally are not, at least not in a way that creates civil liability. The Supreme Court established this principle in Descheny v. Winnebago County in 1989. Joshua Descheny was 4 years old when county social workers began receiving reports that his father was abusing him. He was twice hospitalized with suspicious injuries. The caseworker made monthly visits and noted concerning wounds. Then, Joshua was severely beaten by his father, suffered massive brain damage, and was confined to an institution for the rest of his life. Joshua's mother sued the county, arguing that the department's failure to intervene violated Joshua's due process rights. The Supreme Court ruled against Joshua. The Due Process Clause protects individuals from the government. It does not require the government to protect citizens from each other. The government, the court said, has no affirmative duty to protect members of the general public. The court did recognize two exceptions. First, a special relationship. When the government takes someone into custody, prisoners, detainees, individuals involuntarily committed, it assumes an affirmative duty to protect them. Second, state-created danger. When government officials themselves create or increase the risk of harm to an individual. In Kennedy v. Ridgefield City, an officer promised to warn a crime victim before contacting her alleged attacker's family. He broke that promise. The attacker was then alerted, and he later shot and killed the victim's husband and wounded her. The court found that the officer's own actions had placed the Kennedys in greater danger than they would otherwise have faced. On municipal liability, following Monell v. Department of Social Services in 1978, cities, counties, and local agencies can be sued under Section 1983. States and state agencies cannot, due to the 11th Amendment. For municipal liability to attach, the plaintiff must show that the injury resulted from an official policy or custom of the agency, not merely from one rogue officer acting outside the rules. The city must have shown deliberate indifference to a known risk. The bar is high, as illustrated by City of Canton v. Harris on training failures and Board of Bryan County v. Brown on negligent hiring. Beyond individual lawsuits, Section 1983 also authorizes injunctive relief, and federal law provides a powerful mechanism for the Department of Justice to address systematic patterns of police misconduct. An injunction is a court order directing the police department to stop an unconstitutional practice. Violation of an injunction constitutes contempt of court, which can result in fines or imprisonment. In theory, this is a powerful tool. In practice, courts have been very reluctant to issue injunctions against police departments. In Los Angeles v. Lyons, the Supreme Court refused to issue an injunction against the LAPD's use of carotid and bar chokeholds, even though the holds had killed 10 people. The court reasoned that without evidence that Lyons himself would again be stopped and subjected to an illegal hold, there was insufficient evidence of future harm to justify an injunction. In Rizzo v. Good, the court refused to order Philadelphia to revise its disciplinary procedures because only a few officers were responsible for the misconduct. The rare exception is Lankford v. Gelston, where the Baltimore Police Department conducted dragnet searches of 300 homes over 3 weeks looking for 2 suspects in a police killing. The Fourth Circuit issued an injunction and warned that future similar conduct would result in contempt proceedings. The court's language was pointed. Police protestations of repentance and reform offer insufficient assurance when the conduct is as systematic as this. Pattern or practice suits under 42 U.S.C. section 14141 are a more powerful tool. When the U.S. Attorney General has reasonable cause to believe a law enforcement agency engages in a pattern of constitutional violations, not isolated incidents but systematic practices, the Department of Justice may seek a court order requiring the department to correct those practices. The result is typically a consent decree, a negotiated agreement under which the department commits to specific reforms monitored by a court-appointed independent overseer. Examples include Cincinnati, which entered a decree that was later lifted after the department successfully implemented reforms, reducing police shootings of African American citizens significantly. New Orleans entered a 122-page consent decree in 2012 following a DOJ investigation triggered by officer killings during Hurricane Katrina. The Ferguson investigation in 2015 documented a pattern of racially discriminatory enforcement practices. Cleveland agreed in 2015 to ban pistol whipping, warning shots, and shooting at moving vehicles, among other reforms. The use of consent decrees has been politically contested. The Sessions Justice Department declined to enter any new court-monitored decrees, preferring voluntary collaborative reform. The Garland Justice Department reinstated the use of consent decrees and has initiated new investigations. This chapter also covers two additional civil remedies: Bivens actions against federal officers and state tort suits against any law enforcement officer. Section 1983 covers state and local officers, but what about federal agents? FBI agents, DEA agents, Border Patrol, Secret Service. Before 1971, there was no federal statute providing a civil remedy against federal officers for constitutional violations. In Bivens v. 6 Unknown Named Agents, the Supreme Court created one. The facts of Bivens are as striking as the facts of Monroe v. Pape. 6 FBI agents went to Webster Bivens' apartment without a warrant, manacled him in front of his family, searched the apartment, arrested him for violating federal drug laws, took him to the federal courthouse, interrogated him, booked him, subjected him to a visual strip search, and eventually released him. Bivens filed suit seeking $15,000 from each of the 6 agents for the humiliation and mental suffering he endured. The court acknowledged there was no specific federal statute authorizing the suit, but it held that the very essence of civil liberty requires that every individual have the right to claim the protection of the laws when injured. The court created an implied damages action directly from the Fourth Amendment. Bivens' actions have since been extended to the Fifth Amendment, right against self-incrimination, and the Eighth Amendment prohibition on cruel and unusual punishment. The elements are essentially identical to Section 1983, color of law, constitutional violation, no immunity. Federal judges and prosecutors have absolute immunity. Federal agents have qualified immunity. Crucially, Bivens suits can only be brought against individual officers, not against the federal government itself or federal agencies. The court has increasingly restricted Bivens in recent years, declining to extend it to new contexts, including cross-border shootings in Hernandez v. Mesa, citing the separation of powers and the need for Congress, not courts, to create new causes of action. State tort remedies provide a parallel, but different avenue for relief. An officer may be sued in state court for assault and battery, false arrest, false imprisonment, wrongful death, trespass, or intentional infliction of emotional distress. These claims are difficult because officers have official immunity. They are not liable unless the tort was committed willfully or maliciously. The standard is preponderance of the evidence, which is lower than the criminal standard of beyond a reasonable doubt. And unlike in a criminal case, the plaintiff in a civil case receives monetary compensation directly. The last two remedies we will cover are criminal prosecutions and administrative disciplinary procedures. Criminal prosecutions of police officers are rare despite the seriousness of many incidents of police misconduct. State prosecutors depend on the cooperation of the local police and are reluctant to bring charges against officers. Juries are hesitant to convict police officers, and the witnesses available to prosecutors are often not credible. Fellow officers who agreed to testify in exchange for a reduced sentence, or drug dealers and convicted criminals who were victimized by police misconduct. State criminal codes provide the same legal framework for prosecuting officers as for any citizen. Homicide, assault, sexual offenses, bribery, extortion, trespass. The dual sovereignty doctrine means an officer can be charged in both state and federal court for the same conduct. The Rodney King officers, acquitted on state charges, were subsequently convicted in federal court on civil rights charges. The primary federal criminal statute is 18 U.S.C. Section 242, which makes it unlawful for any person acting under color of law to willfully deprive an individual of a constitutional right or a right protected by federal law. The leading case interpreting this statute is Screws v. United States, in which a Georgia sheriff and 2 deputies were convicted of beating a handcuffed black detainee to death. The key word in the statute is willfully. The government must prove specific intent to deprive a person of their rights, not just that the officer acted unreasonably. Between 2005 and April 2021, 139 officers were charged with murder or manslaughter for on-duty shootings. 44 were convicted, with 42 cases still pending. Most convictions were for lesser offenses, and only 7 officers had been convicted of murder. Many high-profile cases involving the police killing of African Americans resulted in acquittals or no charges. I want to close with what the chapter calls testifying, the fabrication of facts by police officers in sworn testimony. The New York Times documented 25 or more cases since 2015 in which judges or prosecutors concluded that core aspects of an NYPD officer's account were likely fabricated. Officers routinely claim that drugs or weapons were in plain view when they were actually discovered in unconstitutional warrantless searches. NYPD policy calls for dismissal for intentional false statements, but in practice, officers who testified have often been promoted. This problem undermines the entire criminal justice system, not just the individual cases affected, but public confidence in the rule of law and the integrity of police testimony in general. Administrative remedies are the final category. Internal affairs divisions investigate complaints within the department. Cases may be found unfounded, exonerated, not sustained, or sustained. Only about 10% of cases are sustained nationally, and most result in modest penalties. External civilian review boards, present in about 80% of large departments by 1994, provide independent oversight. Models range from full investigative authority with power to recommend discipline to pure oversight and mediation. Let me bring Chapter 11 together with the 6 key takeaways. First, the exclusionary rule is not the only or even necessarily the best remedy for police misconduct. 3 additional categories of remedies target officer accountability directly: civil suits, criminal prosecutions, and administrative discipline. All 3 may apply to the same officer for the same conduct simultaneously, without implicating double jeopardy. Second, Section 1983 is the primary federal civil remedy against state and local officers. 3 elements must be established: color of state law, violation of a constitutional or federal right, and the absence of an immunity defense. Section 1983 suits may also be brought against supervisors when there is an affirmative link between their orders and the misconduct, and against cities and counties when an injury results from official policy or custom. Third, immunity doctrines significantly limit who can be held liable and when. Absolute immunity protects judges, prosecutors, witnesses, and jurors for their judicial functions. Qualified immunity protects police officers unless they violate a clearly established right that any reasonable officer would have known about. Casella v. Hughes illustrates how high that bar has been set. The court granted immunity to an officer who shot a woman holding a kitchen knife within a minute of arrival, without deciding whether the shooting was actually constitutional. Fourth, the police generally have no affirmative duty to protect the public from private violence. DeShaney is the foundation of this rule. Two exceptions exist: the special relationship exception for individuals in state custody, and the state created danger exception for situations where officers themselves increase the victim's risk. Fifth, municipal liability under Monell allows cities and counties to be sued when an injury results from official policy or deliberate indifference. Bivens actions provide an equivalent civil remedy against federal officers. State tort suits provide an alternative avenue with a lower standard of proof. Pattern or practice suits by the DOJ can reform entire departments through consent decrees with court-supervised monitors. Sixth, criminal prosecutions of officers are rare but significant, especially under 18 U.S.C. Section 242 for willful deprivation of constitutional rights under the color of law. Administrative remedies through internal affairs and civilian review boards provide non-judicial accountability mechanisms, and the phenomenon of testifying, officers fabricating sworn testimony to cover for unconstitutional conduct, represents a deep challenge to the integrity of the entire system. That concludes Chapter 11. Thank you for watching, and I'll see you in the next lecture.